this. We had stakeholders under government and public institutions. These are actors with statutory mandates that include Bank of Uganda, Financial Intelligence Authority, National Planning Authority, Uganda Human Rights Commission, the parliamentary committees. We also had another cluster of legal and professional and organizations focused on the law, like Uganda Law Society, like East African Law Society, the Law Development Center, Center for Constitutional Governance that had in their entourage former ministers of government. Independent legal and practitioners who forwarded multiple submissions. We had political actors and movement, political parties, politically affiliated formation. These include Alliance for National Transformation, Forum for Democratic Change, National Unity Platform, the People's Front for Freedom, and for the record, the Hansard must capture this right honorable speaker, that Uganda People's Congress appeared and gave their views. And that the leader of opposition also appeared and gave his views. I'm mentioning for the capture of the Hansard. We also entertained private and business associations that include the Chamber of Commerce, Kampala Traders Association, Kampala City Traders Association, Uganda Small Scale Industries Association, Uganda National Traders Association, the Gen Z's Business Owners Association, Innovation Village, the startup ecosystem, and the independent private sector consultants. We did not stop there. We entertained financial, insurance, economic sector actors. These include the sector-specific institutional stakeholders that include Uganda Bankers Association, supervised financial like banks, mobile money operators, via sector submission. We also entertained Payment Service Providers Association. We also entertained Uganda Forex Bureau and Money Remittance Association. They too appeared and gave their views. We also considered digital telecom media actors in communication broadcasting and digital economy. Include communication sector operators, National Association of Broadcasters, media practitioners, journalists, and journalism practitioners. We also entertained the civil society and non-government organizations, both domestic and international civic actors that include Anti-Corruption Coalition of Uganda, Foundation for Human Rights Initiative, Legal Aid Providers Association, the Rotary Uganda, Women Pro Bono Initiative, Country Directors of International Network, and various national NGOs also submitted. We also entertained international organizations and development actors under these multinational organizations and international cooperation actors. These include United Nations country team, international NGO community, collectively represented. We did not stop there, right honorable colleagues. We entertained labor, religious and social institutions that include NATO, that include Interreligious Council of Uganda, that include Muslim Organizations Coalition and other faith-based organizations. We entertained health, scientific community and public health research institutions, e.g. Uganda Medical Association, Uganda Virus Research Institute, People's Living with HIV advocacy groups. We also entertained education and academic sector that include Makerere University, Academic Staff Association, universities and academic researchers, student group and members of the guild also submitted. National Union of Disabled Persons of Uganda Lawyers Voice on Climate Change, Gender Rights and Advocacy, Climate Advocacy groups. We also entertained diaspora transnational communities, Ugandan actors, the Global Forum. This is an organization that groups all Ugandans in the diaspora. The Cheyo Association, NUP Diaspora Chapter, Individual Diaspora Submission. We went further and entertained professional and individual submission. These are unaffiliated and cross-cutting. Independent consultant, individual citizens, business professional, researchers. Honorable Speaker, we consulted documents. Consequently, the committee recommendations reflect a balanced sense of stakeholder perspectives in the key findings and salient observations. Right, Honorable Speaker, permit me present key findings and salient observations on the Sovereignty Protection Bill of 2026. Introductory consideration. Looking at the scope and interpretation of clause 2. Before presenting its findings, the committee found it prudent to clarify the key interpretive issue of clause 2, which is application of the bill. Clause 2 sits at the core of the legislative framework, and it defines the reach of the law and it determines who is regulated and what circumstances and for what conduct. The committee reviewed the Honorable Attorney General's comment, noting that clause 2 limits the bill to specific activities tied to foreign influence. According to the learned Attorney General interpretation, the bill does not apply to a person generally, to all persons generally, that it applies only to persons acting as agents of foreign actors, and that even then, only where such a person engaged in specific conduct, including influencing policy, political processes, or public decision-making for the interest of foreign. Attorney General clarified that clause 2 is meant to limit the bill, not expand. He guided that it applies only to agents of foreign actors, only when they engage in influence-related activities, e.g. affecting government policies or public decision-making. In addition, the learned Attorney General noted that the bill is activity-based, not identity-based. So ordinary transactions like remittances, businesses, family support are excluded unless tied to regulate influence. On this reading, the bill presented a targeted regulatory instrument aimed at structured foreign operation rather than legit international engagement. However, the committee observes that this interpretation, while persuasive as a matter of policy intent, is not shared by the majority of stakeholders. There is a gap between the agency's intended narrow scope and how the bill is actually drafted. When clause 2 is read together with broad definitions in clause 1 and the expansive list of activities, including concepts such as influencing public opinion and activities that the minister may prescribe, stakeholders interpreted the bill as having a much wider practical effect. The East African Law Society, for example, in their submission, warned that the term agent of a foreign in clause 2 could apply to regular economic, professional and family connections, such as employees of foreign businesses, traders, and those receiving support from relatives abroad. The Law Development Center noted that clause 2 does not distinguish harmful actions from lawful ones. So the people could be held liable simply because of their associations, not because they cause any harm. This divergence, honorable colleagues, reveals a fundamental issue. The intended limitations of clause 2 are not sufficiently clear on the face of the law, creating uncertainty as to the boundary between harmful foreign influence and legitimate activity. While the Attorney General maintains that clause 2 limits application to regulated activities, stakeholders consistently note that this limitation is not clearly reflected in the draft. Therefore, the committee found that the line between harmful foreign interference and legitimate activities is unclear. Clause 2 is meant as a safeguard, but not effective to limit the bill. This gap policy and the law shapes all the committee subsequent findings. 5.2 understanding sovereignty. We looked at what the 1995 Constitution says versus the bill proposes. Sovereignty under the 1995 Constitution as amended. This committee discussed sovereignty referencing the Constitution of